Ready? All right, it is now 5:01 p.m. on the 9th of January, 2023, our first policy committee meeting of the new year. A quorum is not present, and just for the record, I don't believe Chris is going to join us in person or by video. Is that right?
Yes, you're right.
Any public comments,
I don't.
Connie? None? Okay.
None.
Well, then let's move forward and get to work here. Matt, take it away.
Trustees, thanks for being here tonight. We are going to walk you through some recommended policy changes after the TASB policy review that we addressed this last year. This is the next round of them, so we're going to walk through. We don't believe any of these are not appropriate for Belton ISD, otherwise we would have made some changes and talked to you in depth about it. So we'll walk you through them real briefly. Please ask questions along the way if you need to. I'll go ahead and take BAA local board legal status, powers and duties. As you noticed in this one, this is a local policy, and TASB's recommendations were that the board legal duties are outlined in legal policy, so there's no reason to have a local policy for that. So this is just a deletion of that policy.
So just a redundancy.
Correct.
Okay.
And then item 8.2, I think, is Todd Schiller.
Hey, Matt, while Todd's coming up here, and this is a continuation of the review that was done in March of last year.
Correct. Yeah, in the spring of last year, and so what we've done over the years, we broke the policies up into chunks to address. As you remember, we had over 40 different local policies that we were looking at, and so we broke them up into chunks so you could review our recommendations along with TASB's. In all of these, what we ask our administrators to do is look at TASB's recommendations and decide what implications that has on us as a school district in the way whether or not we accept their policy recommendation, and then we bring them forward to you all. If there's something we disagree with, we'll tell you that, we promise. And for these, we'll walk you through the changes that they're recommending.
So on DVD local, that is regarding employment requirements and restrictions. Really the main changes there center around title of who that should be, any conflict of interest forms that are done, who they should be submitted to. And then there is a statement that's added just to kind of match your current practice on the last page there about an employee is prohibited from tutoring their own students for pay. And it's really just documenting that, which is currently what we've been doing. And then on DCE local, that's a policy that we haven't had in place. It's really just an addition to match our current practices with non-Chapter 21 contracts. And so non-Chapter 21 contracts are offered to individuals who are in certain positions that do not have SPEC certification. So if an individual has an SPEC certification, you are required by law, education code, to provide a Chapter 21 contract. And so we do have some positions that aren't SPEC certified, and the position does require them to be SPEC certified, and those individuals receive non-Chapter 21 contracts. And it's part of the list that y'all approve every year.
Any questions on DVD?
On page 4, I'm kind of embarrassed, it's kind of petty, but an employee shall disclose, should it be to the? We need to add a 2 in there, a TO.
What policy are we looking at?
On page 4 at
Oh,
the top.
you're right.
Absolutely. To the,
We will add that back on.
and then on page 5, we've got office at the top and then offices at the bottom. Should we?
Be the same.
We want to make those changes.
All right, that's done. And then I got a question about page 6. Why is it that if an employee's contract has terminated, in other words, we finish the contract, it's expired, why do they have appeal rights?
And this is on policy DCE local
Yeah,
under
page
the
6.
appeal of employment actions.
Yeah. Why would they have appeal rights? In other words, if I've got a contract with you and my term has ended, then, you know, we split the sheets. Why should I have an appeal right?
Well, if you've got an individual that's on a term contracts roll, unless the board takes action to non-renew that contract, then that contract contract's gonna automatically.
So it's in a non-chapter 21 also?
Yeah, it'd be the same thing on the non-chapter 21 as well.
Oh, okay. Does that have to happen in there? Does it have to be that way? We do on the other, chapter 21, because the state requires that.
Right.
But do we have to have that provision in a non-chapter 21
I think we
contract?
probably would need to talk with Holly.
I would have to ask Holly. My assumption is that we wouldn't, but
Yeah, I don't know. I mean, I don't know if we want to do that as a district. It's just,
Yeah.
Food for thought.
yeah.
I will tell you, there's very few individuals that receive a non-chapter 21 contract.
Oh, okay.
We're talking 5.
It's Oh,
It-
okay.
It's a very small. number.
very small. But at the same time though, if we have that in there, we don't have to have appeal rights.
That's right. It protects us a little bit more.
Yeah.
Yep.
It'll protect us a little bit
I
more.
think we can ask that question.
Okay.
Absolutely. That's a good question. Hadn't thought about it like that.
Okay. We go to page 7 now.
I think that's Mike Morgan that's up now. FEE local. And then FFAC, FM, and FMG is all Mike.
So FFE local is it's a dated policy. It addresses students being able to leave campus during lunch, which has not been a practice in Belton for many, many years, from my understanding. And also about leaving campus at lunch or any other time without administrative approval, and the possibility that they could be subject to disciplinary action. And administrative approval would be going through a sign-out process or a parent call-in process and things like that.
This is a moot policy.
TASB's recommendation is to delete it. These are items that are covered in student and parent handbook and in campus guidelines and procedures that is readily available on websites and campus handbooks and things like that. The procedure of how to sign your kid out and the point about the leaving campus for lunch is a moot point. We haven't allowed that, nor will we go to open campuses anytime in the foreseeable future that I can tell.
I want to reiterate that, because we're deleting this policy does not mean that we are going to open
Right,
campuses.
right.
So we're just being clear.
These are all things that are covered procedurally in campus handbooks and in our student
In
code.
1978, we could leave without permission.
That's right.
Well, and we used to have, it was the weirdest thing, when we would have final exams, they would allow for open campus lunch. Does that make sense to you? Does that make sense to anybody rationally?
In fact, it seems like it's the wrong
Anyway,
thing
it's
to
like
do.
the worst idea
Yes.
possible. So, plus there was nowhere to go.
Yep.
So the consequences for being out of area or off campus without permission or proper procedures would not be impacted. It's just saying we don't need a policy for this, and that way as we do adjust sign out practices and things like that, we wouldn't have to go back and adjust policy every time that we do.
All right.
Any questions on FEE?
Jen? Page 8.
So I may throw a curveball at you on this one. I didn't have a chance to grab that. I was talking with Mary Lisa. So this is the practice, this is the TASB local recommendation for FFAC, which is some of it's pretty standard. Some of it has been individualized to Belton ISD. Y'all can remember in the past, we've talked about the non-prescription medications for athletic trainers. We've also talked about the epinephrine. There's one line in one section here about the off-campus use of epinephrine that was brought back in by TASB as a recommendation, since we use that. Currently, we do not administer unassigned epinephrine off campus, so I've got one of two options, either to bring this policy back next month with that omitted, or make some revisions in it prior to the second reading in February.
Conflicts will
It's
be-
not gonna change our practice of what we're doing right now. We do have unassigned epinephrine on each campus. We do have individuals trained on each campus to administer that epinephrine, and we have used it in several instances for kids that are having an allergic reaction. This is 100% my fault, is I didn't realize or catch that the off-campus portion had been added during the policy review. And so I would feel best if you just let me bring it back next month. We knocked it out and be done
Do
with it.
you like that provision?
About the off-campus,
Yeah.
I think it would change some things procedurally for us a little bit,
Okay.
so I would want to discuss that with Mary Lisa, and it would really pertain more to extracurricular activities and things like that. So I think before I say let's omit it, or before I say let's commit to it, let us have a little more of a discussion on that and make sure we feel good about it.
One comment about the bottom, page 8, it says the district shall, so it makes us, it obligates ourselves, we obligate ourselves to make
Okay.
the purchase.
I'll look at that section of it as
Maybe it
well.
should be
So.
may, or, I don't know, I mean, whatever the good practice is.
So I would ask that give us a little more time to talk about off-campus epinephrine and talk about that word shall. Is everyone okay with me just bringing this back next month? It won't change our current practice of what we're doing, but I don't wanna have to bring it twice. There's also, I will say this, a possibility, we've been looking into, the potential of having, kind of just similar to the unassigned epinephrine, having some Narcan, on campuses as well, so that might give us a little more time to research that and maybe
Which is
bring that on
what,
back at
Mike?
once if we choose to.
What is that?
It's the antidote for, certain types of overdoses, fentanyl and things
The
like
fentanyl,
that.
right?
So-
Yeah.
But I think for this one, I think we can go, I'm totally good with bringing it back next month. So
Okay.
we can do a little digging and stuff, and then we can research, because the other piece would add a different layer to it.
It could, it very well could, so, if that's acceptable to
Absolutely.
everybody, I'll just bring it back next month. FM, FM, if you can see where the red line, it just, like, the TASB recommendation is to take away, students shall be allowed unlimited extracurricular absences, and just say that the district shall not limit students' absences. So the UIL, does have a provision that if you want to, you could set a limit on extracurricular absences. The stance of the district has long been that we don't feel like that this is being abused by students, and we definitely don't want to put a policy in place that would limit a student, particularly in springtime, their ability to participate in extracurricular activity because they're going to exceed absences. So your kids that are multiple sport athletes, or kids that may do more than one fine art competition competitively, or your ag kids that go to a lot of shows and also play sports or do fine arts on top of that. If we were to limit that, that might make them make some choices about what extracurricular programs they could do.
But it hasn't been a problem for us.
We do not feel like it's been abused. We don't feel like it's been a problem. These students are, for the most part, are kids that do a really good job of making their work up when they miss for competitions and things like that. So, we're not adding any power, and we're just changing the wording of how it's written in the policy.
Mike, this is a quick aside to that, and this has nothing to do with policy, well, it might. In the past, if a teacher counted them absent inadvertently, accidentally, even though they had a UIL excused absence, it then became the student's responsibility to go to each one of those teachers and prove once again that they were out for a excused reason, which high school students aren't gonna do,
Right.
just telling you.
It should be something as simple as referring back to a release list and having an attendance clerk
Yeah,
fix it for all
you would
periods,
think,
so.
but in the past, that has not been the case. So
Okay.
when we would call and say, well, he was out for band, he was out for, whatever, then they'd say, well, he has to go to the teacher and say that, it's
Oh,
like,
I could check on that and see. We need procedurally,
Procedural, yeah.
they should never have to go to the teachers. That should be taken up between either the coach or the sponsor on behalf of the kid with the attendance clerk, and they should be able to get that solved. Now, I do remember back from my days in athletics, there would be a check, because there could be sometimes that a kid was on the release list and the kid didn't show up, didn't make the bus or whatever, and then that has to be communicated out as well, so. Yeah, we can look into that, make sure that a student shouldn't have to do that, so we can look at it, make sure that it
that'd
doesn't
be
happen.
good.
And in FMG, TASB's recommendation on this one as well is to delete this policy. It's kind of, it talks about students who participate in school-sponsored trips, the requirement to use transportation provided from the district, and except as otherwise permitted. We feel like, and TASB kind of feels like this is something that's covered in campus, department, and team handbooks, and they're gonna set their rules, and usually the students do ride school transportation, but there's usually some type of procedure in place where students can sign out, ride home with their parents, and those sorts of things. But the stance on TASB on this is that we don't need this in policy because it's gonna be covered in our department campus handbooks. We do approve overnight trips. Actually, I I sign off on student overnight trips, and we have someone else that signs off on employee overnight trips, and then out-of-state trips has an approval process as well. So in practice, it won't change anything for us, but it's just saying that there's no reason to have a policy for this.
Any questions on any of those four from Mike?
No.
Excellent.
Thank y'all on that.
This next one is not under the TASB policy review, local policies. This is a separate one, and this is a result of our change to policy CKC local. And in policy CKC local, when we changed that, it specifically outlined that there are a couple of employees based on training requirements and based on board policy that could carry a firearm in the district. Then this policy needed to be changed to be in alignment with that. So you see the red line there, or the red items there under exceptions number 1, and it says use of possession of a firearm by a specific employee is authorized by board action. So if the board takes action to say an employee in the district can carry a firearm, then that is allowed, it is an exception under this policy. Any questions on that? Great.
CKC is pretty good policy.
So that covers our review of the 7 policies under the TASB policy review, and the 8th one is DH local that we just took a look at. Any questions on any of those policies? The plan is number 5, FFAC local that Mike talked to you about, is that we will bring that back to policy committee next month. This will not be as a second reading. That one will not be brought forward as a second reading in our regular board meeting, but the others will all be brought forward as a second reading. Does that sound good?
Sounds good.
Okay. Last thing is Mike, again, on the student transfer application. This is a follow-up, and I know Mr. Ford is out today, but he had requested in policy committee meeting that we take some time and share our transfer application and review that transfer application as well as the policy committee. So Mike's going to walk us through that.
So the request came as we looked at, as we updated policy, there was actually FDA and FEB local. We've looked at these several times over the past few years. The first significant update was in September of 2019. We made another amendment about a year after that, and then we made this last one back in November. And the discussion was coming from discussions with TASB and with our attorney, is to have something in there that says reasons determined by the administration. That change had already been made, but TASB's recommendation was to put "and as reflected in the transfer application or agreement." So to do that, I pulled basically the transfer guidelines that are on our website that parents have access to as they get ready to enroll in the transfer process. And then on the actual Google form that the parent fills out and submits, it says on there, I have read the transfer guidelines, and I do understand these are the people that are eligible for transfer, and these are the ways that transfer could be basis for revocation. So the one thing I wanted to point out is this aligns identically with policy. There aren't any surprises in the transfer guidelines that are posted on the website. There's no surprises in the application form that the parent signs. I mean, the reasons for a transfer are the same, and the basis for revocation is the same. This gives a little more specifics, like when the transfer window opens, when it closes, when you should expect to get the information or the decision back on the transfer application, and the cost and the tuition fees and things of that nature.
So this year's will be March 11, 20.
This one's going to be tied a little bit to elementary attendance boundaries. So as we make final decisions on elementary attendance boundaries, we will need a period for families to digest that and see where their attendance boundaries lie, and then open the transfer window after that. So we have not gone live yet. Typically, the last couple of years, we've gone live within the first 10 days of February and let that open until about spring break. We've had about a 5 or 6 week window for people to apply, and then people could apply after that window closed if circumstances had changed. They moved, new to the community, change in military orders, change in family status or guardianship. and those sorts of things. So we've been generous about allowing people to apply late if they have changing circumstances, but the bulk of the 1,000 or so transfer applications that come in every year usually were received within that transfer window.
The most important observation for me was no conflict between FDB and, what is it,
Legal,
and the local.
that's right.
So it just tracks it, and if anything, it just provides a little more clarity.
And just as on that, FDB legal is kind of the rules that every district has to play by. I mean, and an FDA and FDB local are kind of the ways that we've specified those to meet our needs as well. So I will say this, the data, we're actually at a lower number of inter-district transfers this year than last year, and we have not exceeded that 4% threshold that we've kind of set as a district that we don't wish to exceed. Also, in both categories, the majority of our transfers are employees' children, so it's something for our district to have employees have the ability to have a kid at their campus or at a campus close to them to be able to handle those types of situations. And the vast majority of either denials or revocations, which there aren't a lot, usually has to do with attendance or with student behavior issues. So if a student has significant behavioral issues or chronic absenteeism and things like that, that would definitely impact their ability to be a transfer student.
Did we decide that we were gonna approve this every year, the form? Is that what we did? No. Okay.
No, this is an administrative form based on your policy, but we wanted to make sure we shared it based on that discussion when we reviewed.
So it's
that
something
policy.
that, did we decide we're gonna share it every year, or?
I think Chris just recommended, he just requested that.
That's it? You just
Yeah.
look at it, okay.
I think it was probably something that y'all hadn't looked at, we probably hadn't really discussed with you guys, and the biggest thing was it kind of, for Cynthia Bodie, who runs our transfer process, and Dr. Spearman and myself, just to kind of look at it and make sure we didn't have anything contradictory in the guidelines and the forms and in policy, since we've updated policy several times, and we feel confident. There are some things like, we wouldn't put the tuition fee in policy. We just say we will charge a tuition fee, so this would give us the ability as a school district and as a board, if we wanted to raise or lower that, we could. And then also things like the closed campuses. Right now, we've had 5 closed campuses. Those are listed in the guidelines that the parents sign off that they've read those guidelines. But we're not gonna list those campuses specifically in policy, because we would have to change it every time we open or close campuses. In policy, we would just say that the district reserves the right to close certain campuses for new transfers if they're getting close to capacity.
Understood.
Mike, on the tuition fees, I just noted this, and I've read this numerous times, I never saw this. There's a bullet that says full-time BISD employees are exempt from transfer fee. Is that, do we mean tuition fee by that?
That's the tuition.
Okay,
Yes.
sounds good. So again, that goes back to what Mike talked a little bit about employee recruitment and retention. As an in-district employee, you have the ability to transfer your student without that fee.
And we did put the military discount in policy. We didn't set the amount, but we did say that child who had a parent who is active duty military shall receive a 50% discount tuition. So that was something that we brought to y'all in one of the updates on this policy, and felt like that was being with our proximity to Fort Hood and our growing number of military families, that seemed like something that seemed like the right thing to do for our military families.
Any questions on transfer application?
We will keep y'all updated on the process, when the window opens, those sorts of things, and then, we definitely will come back to the board as part of our attendance boundary process on the recommendation that we'll bring to y'all on how to handle transfers throughout the reboundary process as well.
Thank you, Mike.
Thank you.
Thank you, sir. Yeah, it's just you and I. Any issues or concerns for future agendas?
I have none.
Any requests for reports from the administration? We stand adjourned.
Sounds good. We'll have to let our facilities committee know that there's a 26-minute meeting.
26 minutes.